Thank you for joining us today, and welcome to this introduction to Gard's new rules for charters and traders. I'm Terry J. I'm responsible for charters and traders underwriting at Gard, and I'm based at our head office in Arendal, Norway. So Gard has been covering charters risks, P&I, FD&D, and traders risks for almost 40 years. So we're not introducing any new products here. We're just introducing some new tools to make it easier to access existing products. I'll be joined by my good colleagues, Craig Johnston, who is the head of Charters and Traders Claims, based in our office in Singapore, and Helena Biggs, who's a senior lawyer in our FD&D team in London. And behind the scenes, we're joined by our special advisor, Kim Jeffries, who's also was the head of Charters and Traders Claims before Craig. The four of us, Kim, Craig, Helena, and I, drafted the new rules. We're also counting on some help from our good colleague Elias Baca, who's here in Arendal, and he's doing the production today. So what we'll do is we'll walk you through the transition to the new rules for charters that take effect the 20th of Feb 2025. We'll explain why we've done it, how they'll look, what the big changes will be, and in about 20 minutes, we'll open up to questions from the audience. And you can actually, if you have a question now, you can post your question during the presentation. Just use the Q&A button at the top of your screen. So currently, our cover for charters is written on the basis of this document here. It's the rules for ships. And this is a pretty extraordinary document. The rules for ships has been developed over decades by dozens, if not hundreds, of different authors, refining, revising, taking away old risks, adding new risks as circumstances changed. And basically it's a collective project of all of the clubs in the international group, and it is the code that underlies liability insurance for 90% of the world's commercial fleet. But at its heart, the rules for ships is a code for ship owners, and most of them are covered on the basis of mutual cover, which means that the ship owner is entitled to indemnity, but they're also at risk of contributing additional funds if their club has a bad claims period. So it's not very surprising that the rules for ships are not a perfect fit for a very different group of clients, the charters. So to give a few illustrations of some of the drawbacks of using the rules for ships for charters, there are quite a few provisions in the rules for ships that just don't apply to charters. For instance, there's provisions dealing with cover for liability under crew contracts. Charters aren't signing crew contracts, so this doesn't apply to them. Ship owners are obviously exposed to the risk that they may have to contribute additional funds if their club has an overspill call. So this is the unforecast supplementary call that I just mentioned. This doesn't apply to charters. So in addition to those clauses that don't apply, there's also some clauses in the rules for ships that are completely contradictory to what we cover for charters. And a couple of illustrations of that would be the exclusion in the rules for ships for war risks, which we do cover for charters, and damage to hull, which we also cover. It's excluded under the rules for ships, but it's one of the most important risks that a charterer faces. And finally, there's all of the risks that are simply missing from the rules for ships. For instance, what sort of cover a charter has in a general average situation for their freight and bunkers at risk, or what kind of cover a charter is entitled to if they stem off-spec bunkers that could damage the vessel and they've got extraordinary expenses to get those bunkers off. And the way we've solved all of those missing pieces of information and all of the confusing and contradictory provisions in the rules for ships is we've solved this by a very lengthy certificate of entry that brings back, takes in the missing provisions, corrects the contradictory provisions. There's a lot of use of notwithstanding the rule for ship provision X. This is covered under this certificate of entry. So it's worked, but it has produced a fairly lengthy and complicated certificate of entry, and it hasn't always been very easy to use. So this was the dilemma we faced, and we realized that the rules for ships are familiar. The market knows the rules for ships. They're widely used. All of our peers are using them for ship owners, but we wanted to do better. And that's when we decided that we really needed to build something that was purpose-built for charters, and we needed to start with a clean slate. So this is what we've done. When we developed the rules for charters, our objectives were to first and foremost focus on contract clarity and contract certainty. We wanted the rules, the scope of cover, to be easier to understand, and we wanted to be able to reassure our assureds that they could expect a certain scope of cover. And if they weren't covered, it was also going to be easier to find why not. When we cleaned up the rules and took all of the cover provisions that are currently in the certificate of entry and moved them over to the rules for charters, whenever we could, we cleaned up the language, we grouped provisions together, we removed the redundant or the irrelevant wording. And whenever we saw some sort of slightly antiquated language, we also tried to clean it up in an interest of moving towards plainer, more consistent English, because we think everybody appreciates that this doesn't have to be an obscure document. We wanted it to be easy to read. So here's a couple of examples of some of the wording changes that you're going to see when you look at the rules for charters. Naturally enough, as I've already explained, charterers are not members of a mutual association where they're at risk of having to contribute additional funds. So we changed the language, the member language, to assured. And Gard is no longer the association, the mutual association. We are the insurer. Another wording change that probably is worth a couple of comments here. We're going to be moving in 2025 from cargo owner to trader. Now, we've been covering cargo owners' risks for 25 years, since the late 1990s, when we started with cargo owners' pollution and then transitioned to cargo owners' legal liability. And this is a market term. It's widely available and understood. So this was a bit of a dilemma for us. But one source of some confusion with the use of the term cargo owner is that it does contain a little misdescription or a misnomer. In fact, the scope of the cover for a cargo owner is wider than just a cover for the risks of owning the cargo. So the word owner is a bit misleading. Really, the cover is potentially interesting to anybody who is involved in the buying, selling of the cargo, trading the cargo, holding the bills of lading. Anybody that has an interest in the ownership of the cargo, but may not actually own the cargo at the time of the event. So we opted to change this to commodity trader, shortened to trader, which we think is more descriptive of the scope of the cover. And then one advantage, once we cleaned up the rules and took the missing cover provisions out of the certificate of entry, put them into the rules, grouped things together in a nicer way, not only did we end up with a shorter, cleaner version of the rules, but it also gave us a nice opportunity to improve the readability and the clarity of our certificates of entry. We hope that you will like the results. Now, just to say a few words about the structure, this is how the new rules are going to look. So, as I said, we really focused on trying to group things together in a way that was intuitive. So the first part of the cover, which contains the housekeeping, the provisions, the definitions, is basically an administrative guide to how the cover will work. I should say covers, actually, because there's multiple covers available in the rules. And this is where we set out the provisions relating to termination of cover, capacity of the assured, who can be an additional assured, and so on. Part 2 is where we set out the named risks. This will be familiar. It's very similar to what we have now in the rules for ships. Part 3 is where we set out the defense cover for charters. Helena will speak more to this, but I will flag it's not identical to the current scope of defense cover for ship owners. Part 4 is a new provision. This is where we set out the possibility of cover extensions to traders. So currently, cover for traders is set out in individual certificates of entry, but now with effect from 20th of Feb 2025, the scope of the cover is actually set out and embedded in the rules for charters. And this is both P&I and also our extended defense cover for traders. In Part 5, we set out the exclusions, and this is what we've done with exclusions. When an exclusion was specific to one risk, we set out the exclusion in the scope of that named risk. So that will appear in Part 2. But when an exclusion had wider application, we did this. We put it in Part 5, and so part of Part 5 addresses exclusions that are specific to P&I. Part of Part 5 addresses exclusions that apply only to FD&D, and there's a section on exclusions that apply to both P&I and FD&D. Part 6, the final section in the main body of the rules, is where we set out the provisions for how we handle claims. So how claims are handled between the association and the assured. It's where you find provisions about notification and arbitration and disputes with the insurer and so on. And finally, we have one single appendix in the rules for charters. This is where we set out the market clauses that apply by virtue of our reinsurance. So it's the coronavirus and cyber exclusions, the communicable disease exclusions, and so on. Now, we're going to get into a little more detail to look at some of the more important risks and how they will look after the 20th of February. So I'll turn it over to Craig.
Thanks, Terry. As Terry has said, the cover remains more or less the same. However, we've taken the opportunity to remove the rules and wordings which are not relevant to chartering interests. The net result here is that we actually now have fewer rules. So wherever possible, we have consolidated the rules so that it's easier to identify the rules relating to a particular risk. The personal injury rule is one example, but another example would be the cargo rule, where we have included the provisions relating to electronic bills of lading, which were previously found in the excluded loss rule. In addition, charter-specific rules such as charter's liability for damage to hull and bunker removal previously had to be added to the CO to the certificate of entry, as there were no equivalent provisions in the mutual rules. These have now been imported into the main body of the charter's rules. So overall, the need to cross-refer between the documents forming the contract of insurance has been reduced. This will make the cover easier to understand, to use, and to apply. With that, Helena, I'll hand over to you for the next slide.
Thanks, Craig. So for liner operators that are chartering ships and issuing bills of lading as carriers themselves, there is no difference at all in the wording between the mutual cargo rule and the charterers rule with respect to their liability. So for the operators that are chartering ships, they can rest easy. Cargo claims are all the same. Now, in substance, there is equally no change with respect to our commodity trader clients who own the cargo, but the own cargo exclusion, which was previously to be found in the certificates of entry, has now been embedded in Rule 24, the main body of the cargo rule. The logic behind that is obviously that when an assured owns the cargo, the expectation is that the first party property loss would ordinarily be insured elsewhere. A second addition in terms of the text, but not in terms of the practice, is the addition of a pre-shipment exclusion clause. And this was, we started introducing this a few years ago as a clarification point to make it absolutely crystal clear that Gard is only covering fortuitous risks arising from the carriage of cargo, and this exclusion has also therefore been imported into Rule 24. So an example of where that exclusion might bite would be if you had, for example, pre-shipment contamination. And that's in line with the approach that Gard is not covering the assureds for inevitable losses as the seller of the cargo. I'm going to hand back to Craig now to talk about DTH risks.
Thanks, Helena. The damage to hull wording has been moved from the certificate of entry. The wording is materially unchanged, except that the conditions for damage to hull cover caused by war risks, which were also previously in the certificate of entry, have been consolidated into the rule. These conditions have been updated post the Polar decision. It is clear following that decision that a payment of additional premium under a charter party does not in itself protect a charterer. The conditions have been softened. There are also fewer of them. And the overall effect is that the conditions for damage to hull cover for war risk are less onerous from the assured's perspective. With respect to the war risks themselves, these are excluded under mutual P&I, and consequently owners arrange their own war risks cover in the market. The same exclusion was not applied to charterers' liability cover, but the language previously used in the certificate of entry was a little convoluted with a couple of double negatives, and the remaining conditions and limitations were listed in different parts of the certificate of entry. So we've tried to address these issues. War risks for charterers now has its own rule. P&I liabilities caused by war risks have been expressed positively. This wording and the remaining conditions and limitations have been moved from the certificate of entry and consolidated into a single rule. We think that you will find the new wording for charterers' war risks to be more intuitive and user-friendly. Next slide, please. Similar to damage to hull cover, the bunker removal risk is a specific risk to charterers. The wording has been moved from the certificate of entry into the charterers rules. It includes the same cover for the removal costs and expenses incurred by the assured to avoid or minimize liability for damage to the ship's engines. However, wording has been added to clarify that the cover is also available for the assured's liability to third parties who incur such costs. There is the same cover for hire or demurrage, which the assured is obliged to pay the owners during the currency of a charter party, but cover is now also extended to the assured's liability for time lost where the bunkers are removed after redelivery. The wording of the bunker removal rule is clearer, and the scope of the cover is broader. Next slide, please. As Terry mentioned earlier, this cover was formerly known as cargo owner's legal liability, and it has now been renamed P&I for traders. This is a specific cover for traders, as the name suggests. In other words, those that buy, sell, or own cargoes. The cover has been moved from the certificate of entry to the charterers rules, and whilst the scope of the cover remains the same, the wording has been significantly tidied up. The terms trader and cargo are now defined in Rule 1 interpretation. There is the same cover for P&I risks for the trader, but excluding damage to a loss of the cargo itself, extra cargo handling costs, fines related to the cargo, or liabilities arising from the use, consumption, or the disposal of the cargo following a discharge from a ship. Wording has been added to clarify that the trader is insured first to the extent that they incur liability as a consequence of their interest in the cargo, and second, in relation to an event where the cargo is being loaded onto, carried on, or discharged from a ship. So there is the same cover, but it has been expressed in a way that is much easier to follow. And with that, Helena, I'll hand the mic back to you.
Thanks, Craig. So in relation to the standard defence and the defence for traders, we looked at the mutual rules and we took the opportunity to streamline them. So we took out of that cover some of the dispute types which we thought would be irrelevant to our charter and trader assureds. So, for example, there is now no cover for ship sale and purchase or new building disputes within the charterer's defence, on the basis that these would obviously not be contracts into which our charterer assureds would be entering. Conversely, as defence cover potentially extends to disputes under insurance contracts, there's an express exclusion for disputes with cargo underwriters in respect of own cargo. Now, as before, we've still got our extended defence cover for traders, and that largely mirrors the previous wording, but we have slightly expanded the exclusion which relates to cargo handling operations. So now that does not include disputes which concern the loss of, damage to, or condition of the cargo. So to give you an example of why we expanded that to include condition, if there were a dispute concerning fumigation, that would not be covered, that would fall within the exclusion. And the logic behind that is that the cargo is being affected by an infestation, but it's neither damaged itself nor it's lost. So the introduction of the word condition was felt to be appropriate. Looking at a key administrative sort of function of the club, if we look at the security rule, we have significantly simplified the wording of the rule. But we found in practice, obviously, the charterer's book presents a more complex risk, and the assureds have a much closer relationship with the cargo, and then you also have the existence of a separate sale contract. So the combination of these factors potentially introduces increased scope for cover issues relating to the own cargo or pre-shipment exclusions. Now, often we're asked to help with security for our members, while at a relatively early stage of a case, when the investigations are still ongoing, to try and work out what the underlying cause of the claim was. And we wanted to find a balance. We did have a practice in place already, that we could put up security if we needed to help our assured, but then we would ask for counter security if for some reason cover was subsequently reserved. As I say, that's an existing practice, but we felt that it was a good opportunity to bring that forward and make that part of the standard terms. I'm going to hand back to Terry just to round up on some other changes.
Thank you, Helena. I'll say a few things about some other covers that don't appear in the rules. So our goal was to try to put at least all the main covers that are available in the rules for charters. And of course, I should also say at this point, we had a webinar this morning, and one of the questions was, do all the covers automatically apply to all assureds? And the answer is no. What each assured wants or needs will be is obviously a subject of the individual contract of insurance and will be reflected in the individual policy or certificate of entry. So back to what we tried to do. We tried to put all the main covers that are available to charters and traders in one consolidated set of rules. There are other covers that are available, but aren't in the rules. So we couldn't put them in the rules this year. Maybe in the future we'll be able to change that. But for this year, at least, what we were able to do once we sorted out the rules and cleaned up the certificates of entry was we realized, this was a wonderful opportunity to take those covers, including the loss of bunkers cover, which is something that's taken up by a lot of our time charters, and at least put the cover provisions in the same certificate of entry. So previously, or up until now, the loss of bunkers is set out in a separate endorsement. It's in a different document. As of the 20th of February 2025, a charter with bunkers cover and P&I will be able to see both covers in one policy document. And the same goes for charters that buy loss of use, where the charter has to pay ongoing hire where the vessel is not available to the charter to carry cargo. That cover will also appear in the same P&I certificate of entry. And finally, the same goes for the charter's loss of freight. Let's say that the charter buys cover where they have freight payable at discharge, the vessel is lost during the voyage. So that cover, when it's taken out, up to now, it's been set out in a separate cover note. As of the 20th of February, that's going to be in one document. And we think that this will make it easier to sort of see everything and have a clearer picture of what covers you have with Gard. One exception I should mention here that's sadly increasingly relevant is when we offer cover for war risk buybacks. Currently, they apply in respect of the Black Sea and also the Red Sea. Those covers won't appear in your certificate of entry. They'll continue to be evidenced in separate endorsements because those are really market covers and they're typically for single transits and they're subject to separate terms and conditions. So with that, we're wrapping up the presentation part of our webinar. I'll just sort of recap the points made by all of us. Basically, our goal this year wasn't to change the scope of the cover. We really just wanted to clean up and make things easier to use and more intuitive. Every year, with that said, I mean, we do always fine-tune the cover from year to year. There's always little adjustments. And two of those that would have occurred with or without the new rules is we've made this extension to the cover for removal of off-spec bunkers to include time lost after the vessel is redelivered. Craig's already mentioned that. And we do have a new, it's a company due diligence where we will be requiring in the 2025 certificates that each assured is identified and by the capacity in which we are covering them. So charter, trader, both, or reinsured. So to recap, we moved provisions that were in the certificate of entry, we put them into the rules, we've organized things in a different way. We've basically tried to group things in an intuitive way. We've put the trader provisions into the rules for charters, and then we've reorganized the certificates of entry for 2025 to reflect all of these changes. So overall, we think that these will be good changes. Any change is a disruption, we're aware of that, but we trust that once we all become more familiar with the new layout, it's going to be easier to use. So with that, we're going to wrap up the webinar. For those of you who received an invitation directly from Gard, in the coming week or so, you will get an email with a link to the presentation today. If you received your email from a colleague, if you received your invitation from a colleague or the links to this from a colleague, if you want a copy of this recording, you're going to have to go back to that same colleague and ask for the link to the recording. And then I guess I think we just have to say thank you very much for your engagement and for giving us the time to walk you through this. Thank you for joining.